defendant. State, any objections to the court's recitation?
No objection from the state, Your Honor.
Defense?
No objections.
Alrighty, defense, if I may go ahead and put you in the court breakout room with the court coordinator, and defense, you're excused from there. Thank you so much.
Okay, is my client also excused, Judge?
Absolutely. Was your client here?
He's here and I've talked with him on the phone already. Mr. Henley, if you can just hit leave meeting, I'll update your calendar.
Okay, Mr. Henley, thank you for being here. Appreciate it. I'll note that you were present.
Thank you, Judge.
Have a good weekend, sir.
You too. Thank you.
Thank you. If you want me to, okay. Attorney John Fox.
Good afternoon, Your Honor.
Good afternoon, sir. How are we going to dispose of your case?
It looks like a trial setting, Your Honor, for 12/8 for announcement with trial 12/12.
Let us get on the record on cause number. And court is going to call cause number 675-120, State of Texas versus Jacob Brian Rodriguez. Attorneys and attorneys only, please approach and identify who is before the court, starting with the state.
Ling Han for the state.
John Fox for Jacob Rodriguez, Your Honor.
And we're here for a trial and pretrial conference hearing today, the 11th of August. State, please proceed.
Judge, this is a San Antonio Police Department case, and an offer was extended, believe, on the 9th of August.
That's what I have, Judge.
Thank you for acknowledging receipt of an offer that was conveyed to you by the state in writing. Counsel, how are we going to dispose of this matter, sir?
It's a trial, Your Honor. The dates that I've received are 12/8 and then 12/12 for trial of this year.
State,
No objection, Your Honor.
defense, will the defendant need an interpreter?
No, Your Honor.
And regarding witnesses, will you rely on the state's file and police reports, file a motion, or have the witnesses read into record at this time?
I've previously filed a motion, Your Honor, but I think I can rely on their police report. That's fine.
Okay. But you filed a motion. Do you recall when you filed the motion?
Yes, Judge, it would have been, well, looks like they were filed back on 12/31 of 21.
State, when do you intend to respond?
The state will respond by November November 8, 2022.
Defense, is that
That's acceptable, Your Honor.
all pretrial motions and requests will be in writing. Again, with regard to motions in limine or any other motions that must be arbitrated by the court. Please set for those for a hearing on Friday. State, have you filed any motions in this case?
We have not, Your Honor.
Defense?
Has the state, you're asking me if the state has filed, Judge, or if we have?
No, whether you have filed any motions.
Yes, the date that I gave you previously, the motions were filed on 12/31 of 21.
Sir, does
Okay.
any of the motions, excuse me, any of the motions you filed, do they need to be set for a hearing, sir?
Not at this time, Your Honor, no.
State any discovery issues or concerns?
None, Your Honor.
Defense?
No, Your Honor.
Defense, you've received your e-discovery
Yes, I have, Your Honor. It appears to be complete.
and received your information, sir?
Yes, I believe I have.
Do you waive arraignment on behalf of your behalf of your client?
Yes, Your Honor.
Court orders and admonishes the attorneys to exercise due diligence to ensure that discovery does not impede the execution of trial on the set date of 12 December 2022. And defense to exercise due diligence to notify the defendant of the next court date, barring any motions that you may set for a hearing. The next court date for this defendant will be the 8th of December 2022, in which he must be present for trial announcement. If the defendant does accept the state's offer, the defense must tender a jury waiver and set this matter for a plea within 2 to 3 weeks. State, do you acknowledge the court's admonishments in order?
Yes, the state acknowledges.
Defense?
Yes, Your Honor.
And defense, do you have the email address for the defendant, and can you provide that to the court coordinator? When?
I've already sent it, Your Honor, about 10 minutes ago.
Awesome. State, anything further on this matter?
Nothing further from the state, Your Honor.
And defense, anything further?
No, that's all, Your Honor. Thank you.
Thank you, sir. Subject to your objections, the court understands cause number 675-120, State of Texas versus Jacob Brian Rodriguez. This matter will be resolved by trial on the 12th of December 2022 with a trial announcement date of 8 December 2022. The state does not have any objections to this, and the defendant must be present for trial announcement on the 8th of December 2022. No interpreter is needed for the defendant. The defense has filed a motion for witness list dated the 31st of December 2021, and the state has stated that they will respond by the 8th of November 2022, of which the state defense finds to be timely and sufficient. This is San Antonio Police Department case. All motions and pretrial requests will be in writing, especially any that the court needs to arbitrate. Please set this for a hearing on Fridays. The state has not filed any motions in this case, but the defense has, and at this time does not feel any needs to be set for a hearing. Neither the defense nor the state have any concerns regarding discovery or have any issues regarding discovery. Defense has received the e-discovery and information and does waive arraignment on behalf of this defendant. The defense did acknowledge receipt of an offer in writing dated the 9th of August 2022. Both the state and defense do acknowledge the court's order, admonishments and orders to the attorneys. And defendant's email has been provided to the court coordinator. State, any objections to the court's recitation?
No objection, Your Honor.
Defense?
No, Your Honor.
Defense, thank you so much for your attendance. It's great always to work with a professional. Thank you very much. Have a great weekend, sir.
You too. Thank you, Judge. Take care of yourself. That
Thank you. Appreciate
cough
it.
worries me, but I'm sure you're on top of it. Thank you.
Thank you.
Bye-bye.
Hector Gonzalez the third.
Good afternoon, Your Honor. Oops, my video is off. I'm sorry. Good afternoon, Your Honor. How are you?
Good afternoon. How are you doing?
I'm doing well, Judge.
Good.
Good to see you.
Always, always. Thank you. How are we going to dispose of your client's case, ma'am?
Judge, we have a little bit of a pickle on this one. We have not heard from Mr. Green probably since the last court setting. He doesn't communicate with us. We don't know what he wants to do with this case. We did let him know of today's setting, and Hector just got a quick okay from him, and that's it. We asked him to be here, to be present on today's docket, and he's not here. I was hoping to be able to talk to him. So I'm hoping and praying that we could eke out one more pretrial conference to hopefully get things back on track with him, or in the alternative, file a motion to withdraw on the case.
Right.
I hate to do that, but we would like to try and see if we can get him back on track first, Your Honor.
So counsel, you would not be able to, in all good consciousness, waive arraignment for this defendant?
I could not right now, Your Honor. I would be ineffective assistance of counsel to Mr. Green because he's not been able to communicate with us, his desires and what to do with this case. And without communication from him, we can't make an election for him. He's put us in a difficult position, Your Honor.
Yes, counsel. Let's get a record on cause number 676-489, State of Texas versus Thomas Edward Green. Parties, please approach and identify who's before the court, starting with the state.
Brett Bosis for the state.
Good afternoon, Your Honor. This is Claudine Espinosa, and along with Mr. Hector Gonzalez, we are here for Mr. Thomas Green.
We're here for a pretrial conference hearing today, Thursday, the 11th of August, 2022. State, please proceed.
This case is from the San Antonio Police Department. And State and Defense have conferred previously and an offer has been conveyed.
Counsel, do you acknowledge receipt of an offer that was conveyed to you by the state in writing?
Yes, Your Honor. We do have an offer.
All righty. And counsel, you had mentioned before we got on record. So for the record, you have mentioned something regarding your client, your ability to be able to tell me how this matter is going to be disposed of.
Yes, Your Honor. It's unfortunate, but we've not heard from Mr. Green. We don't know what his election is as to whether we should plead this or try this case. Hector's reached out to him numerous times. He did have today's Zoom hearing information. He simply responded with an okay, but Hector had asked him to be here today in hopes that we could figure out what he wants to do with this case. I did confer with the state, Ms. Linghan, and I also conferred with the coordinator. I did secure a date of October the 6th in hopes that you will grant us one more pretrial conference so that we can try to get Mr. Green to make an election. And if not, that would allow us time to withdraw or file a motion to withdraw and set it for a hearing.
And counsel, so are you able to waive arraignment for this defendant?
At this time, I'm not, Your Honor.
Okay, so we will need to reset this for an arraignment and he must be present at arraignment. He will not be excused. Can you jump in there with the court coordinator, get an arraignment date, and it will not be the 6th? I'll give you 2 weeks. Would that be sufficient for you to?
We will make do with whatever time you allow us, Your Honor.
Okay, would that be sufficient for you to be able to get a hold of him, try to get this resolved? So we'll get to another pretrial conference here.
I would hope so, Your Honor. I really hope so. And if not, if we cannot reach him, that hopefully does give us enough time to regretfully file a motion to withdraw and set it for a hearing.
Okay.
So appreciate it, Your Honor.
Okay, so no later than 2 weeks from today, okay, on a Thursday.
Thank you,
very much.
Okay.
Appreciate it. We're off
Thank
record
you.
on this matter.
Thank you, Your Honor. Your Honor, did you want me to go to a breakout room with the coordinator to secure a date within the next 2 weeks?
Absolutely. Sending you there
Okay.
right now.
Thank you, Your Honor. And from there, may I be excused?
Absolutely. Thank you.
Thank you. Take care, Your Honor. Hope you're
You
feeling
too.
better soon.
Thank you. Michael Young. Didn't we already take care of Melvin Jimenez Hernandez?
Judge, I'm here on that. I don't believe we did. I think I was having some technical issues, but they've been resolved.
Oh, okay. There you are. Okay, yes.
Yeah, apparently I was muted, but I thought everyone else was muted, so that's that was my bad.
Okay. All right, Council, Sir Mike. I know that I've seen. Where is it?
Judge, I think there are two cases here. It's 6762729 and 6666487.
That's correct.
6, that's what I was looking for, right, and as soon as you said it, I'm seeing it, right?
I believe it's
Okay.
43 and 26, Judge.
Thank you.
Yes, ma'am.
6, 7. Oh, wait a minute. Let's get a record on cause number 667, excuse me, I'm sorry, 666-487 and 676-729. State of Texas versus Melvin Jimenez Hernandez. Parties, please approach and identify who's before the court, starting with the state.
Ling Han for the state.
Renee Munoz on behalf of the defendant.
We're here for pretrial conference hearing today, the 11th of August, 2022. State, please proceed.
Judge, this is a Bear County Sheriff's Office case. An offer has been extended.
And defense, do you acknowledge receipt of an offer extended to you in writing?
The defense does so acknowledge.
And how are we going to dispose of this matter, sir?
We'll be requesting a trial, Judge.
Okay, and you have dates?
Yes, Judge. Trial announcement for December 1st, 2022. With trial commencing on December 5th, 2022.
And will an interpreter be needed for your client?
Yes, actually, yes, Judge. An interpreter would be needed.
In what language?
The Spanish language.
Okay. Regarding witnesses, state, I'm sorry, do you object to those dates? The 1st and the 5th of December? Any objections?
No objection, Your Honor.
With regarding witnesses, counsel, will the defense rely on state's file and police reports, file a motion, or have the witnesses read into record at this time?
We'll rely on the reports, Judge. I think that will give us adequate notice in relation to these charges.
Thank you, counsel. State, do you reserve your right to supplement?
I don't believe that will be necessary, Your Honor.
And state, anything further regarding witnesses?
Nothing further from the state.
All motions and pretrial requests will be in writing. And state, have you filed any motions or requests in this case?
State has not filed any motions.
Defense?
No, Your Honor, we have not filed any motions.
Regarding discovery, any concerns or issues, state?
No issues that the state recognizes at this time.
Defense?
Not at this time, Your Honor.
Have you received your e-discovery defense
I have, Your Honor.
and the information?
Yes, Your Honor.
And would you waive arraignment on behalf of this defendant?
We do so waive.
Court admonishes the parties to and orders the parties to exercise due diligence to ensure that discovery does not impede the execution of trial on set date of 5 December 2022, and defense to exercise due diligence to notify the defendant of the next court date, which will be the 1st of December 2022 for trial announcement, and the defendant must be present. If the state does, if the defendant does accept the state's offer, defense will tender a jury waiver immediately and set this matter for a plea within 2 to 3 weeks. State, do you acknowledge the court's order and admonishments?
Yes, Your Honor.
Defense?
Yes, we do so acknowledge.
Defense, the email address for the defendant? Have you sent that to a court coordinator?
If I could, Your Honor, send it this afternoon. I'm waiting to hear back from him with that info.
State, anything further on this matter?
Nothing further from the state, Your Honor.
Defense?
Nothing further from the defense.
With regard to cause number 666-487 and 676-729, State of Texas versus Melvin Jimenez Hernandez, the court understands and orders that this matter will be disposed of by trial on the 5th of December 2022 with a trial announcement of 1 December 2022. This is the court's understanding of the attorney's agreement. The state has no objections to those dates. An interpreter is needed for this defendant in the language of Spanish. The state defense will rely on the state's file and police reports for witnesses. This is a Bexar County Sheriff's Office arrest, and the state does not reserve its right to supplement. All motions and pretrial requests will be in writing, especially those that the state may need, the court may need to arbitrate. Please set those for a hearing on a Friday. Neither defense nor state have filed any motions or concern, any motions or requests in this case. Neither state nor defense have any discovery concerns or issues. This defense has received its e-discovery as well as the information. The defense did acknowledge receipt of an offer that was conveyed to it by the state in writing. Both defense and state do acknowledge the admonitions and orders of the court, and the defendant's email address will be sent to the court coordinator today, the 11th of August, 2022. State, any objections to the court's recitation?
No objection, Your Honor.
Defense?
No objection, Judge.
Counsel, do you have anything further in this court this afternoon, sir?
No, Judge. This would take care of it.
Thank you so much. I'm going to go ahead and put you in with the court coordinator on that email address and further instructions, and you are excused from there. Thank you so much, counsel. Appreciate you being here.
Much appreciated, Judge. Good seeing you. Bye.
Thank you. Attorney Raymond Martinez.
Your Honor, Victoria Cruz present for Raymond Martinez.
Thank you. You have several cases today. We're going back to, let me see. I think.
We have Brandon Sandoval. He is present.
Yes, ma'am.
And another two.
Let's see. More, okay. You have two clients, I guess. Mora has two cases. And Sandoval, do you have the cause number?
On Mr. Sandoval, Your Honor, it is 671-575.
Okay, thank you. There we have it. How are we going to, that's for a jury, that's for a trial announcement, actually. Let's
Yes, Your
go-
Honor.
Okay, let's go ahead and take care of that right now. Is Mr. Sandoval present? You say he's present, right? Yes, there he is.
Yes, Your Honor.
All right, let's get on record on cause number 671-575, State of Texas versus Brandon Sandoval. Parties, please approach and identify who's before the court, starting with the state.
Klingon for defense, or for state, sorry.
Victoria Cruz on behalf of Raymond Martinez for the defense.
Mr. Brandon Sandoval, if you will unmute and respond, please.
Yes, ma'am.
Alrighty, very good. The court wishes to recognize and have the record reflect that Mr. Sandoval, Brandon Sandoval, the defendant, is present in this court session with his attorney. We're here for a trial announcement on record. State, are you ready to proceed to trial on this matter?
Yes, Judge, the state is ready.
Defense, are you ready to proceed to trial on this matter?
Yes, Your Honor.
I will see a need for you to be present at 11:30 on Tuesday. Defense and state, I need for you to be in the courtroom on 11:30 on Tuesday. The jurors will be here right about 12:30, and hopefully we'll get them seated and proceed to and panel them.
Oh, Jesus. I am sorry, Your Honor. 1 second. Your Honor, Mr. Martinez is out of the country this next week. I did not realize that this was for trial announcement for next week. May I be allowed 1 second?
Sure.
Thank you. Your Honor, if I may, I'm sorry, for reasons that you know already, I'm on maternity leave, so I can't be present. Mr. Martinez does have a vacation letter on file, and this setting just kind of, I don't know, that this was our fault. If
Would you like for
Your
me to
Honor,
call you for next week for a trial announcement?
if we could push it back 1 week out, that would be perfect, Your Honor.
Okay, alrighty. So let's go ahead and do that. And I'm gonna put you and your client in the breakout room with the court coordinator, okay?
Yes, sir. Would we be recalling it for the week after?
For a trial announcement, it's actually the week. But I'm gonna let you go ahead and discuss that calendar with the court coordinator, okay?
Understood. Yes, Your Honor.
All right.
Thank you.
And you and your client are excused from that after you settle that matter, okay?
Understood, Your Honor. Thank you. And I'll return for the other 2 announcements.
Oh, okay. Oh, okay. That's good. Alrighty. So, alrighty. You wish to do that now, or you want to take care of those 2 now? Oh, excuse me. I'm so sorry. State anything further on this matter? State
Nothing further from the state, Your Honor.
defense?
No, Your Honor.
Okay, we're off record on cause number 671-575. So do you wish to take care of Mr. Mora now, or do you wish to?
Yes, Your Honor.
Pretrial conference hearing.
No, I have trial dates for Mr. Mora and Mr. Yelverton.
Yelverton, what's the cause number of Mr. Yelverton?
It is 625-513.
Got it. Okay, thank you. All right, can we take care of that now and then you can be excused?
Yes, please, Your Honor.
Okay, let us get on record on 625-513. State of Texas versus John Keith Yelverton. Attorneys and attorneys only, please approach and identify who's before the court, starting with the state.
Ning Han for the state.
Victoria Cruz on behalf of Raymond Martinez for the defense.
We're here for pretrial conference hearing today, the 11th of August, 2022. State, please proceed.
Your Honor, this is a San Antonio Police Department case. It does not appear that an offer has been made at this time.
Defense?
Your Honor, defense would request to proceed to trial with a trial announcement date of December 8th, 2022, and trial date of December 12th, 2022.
Defense, do you acknowledge that you have not received an offer?
Yes, Your Honor, we do.
Okay. State, what say ye to those state dates?
State is not opposed to those dates.
Will an interpreter be needed for the defendant defense?
No, Your Honor.
Regarding witnesses, will you, would the defense rely on the state's file and police reports, file a motion, or have the witnesses read on record at this time?
Defense will rely on the state.
File and police reports?
Yes, Your Honor.
State, any, do you reserve your right to supplement?
That won't be necessary, Your Honor.
And do you have anything further regarding witnesses?
Nothing further from the state.
All motions and pretrial requests will be in writing, especially any that needs to be arbitrated by the court. Please set those for a hearing on a Friday. State, have you filed any motions in this case or
It
requests?
has not.
Defense?
Defense has not, Your Honor.
Any discovery concerns or issues, state?
None from the state.
Defense?
None from defense, Your Honor.
Defense, have you received your e-discovery
Yes, Your Honor.
and information?
Yes, Your Honor.
And you're able to waive arraignment, and do you waive arraignment on behalf of your of the defendant?
Yes, Your Honor, we do.
The court admonishes the attorneys to exercise due diligence to and orders the attorneys to exercise due diligence to ensure that discovery does not impede the execution of this trial on the set date of 12 December 2022. The defense to exercise due diligence to notify the defendant of the next court date, which barring any motions that may be set for a hearing in which the defendant must appear. The next court date for this defendant will be a trial announcement, the 8th of December 2022. If the defendant does decide to accept the state's offer, once it is tendered, the defense will tender a jury waiver and set this matter for a plea within 2 to 3 weeks. State, do you acknowledge the court's admonishments and order?
State acknowledges.
Defense?
Defense acknowledges, Your Honor.
Do you have an email address for the defendant, and have you provided it to the court coordinator?
We will provide that to the court coordinator, Your Honor,
When?
by the end of today.
Okay.
Oh, we do have an email.
Subject to your objections, the court understands that this matter on cause number 625-513, State of Texas versus John Keith Yelverton, will be disposed of by trial on the 12th of December 2022 with a trial announcement date of 8 December 2022. The state has no objections, and the defendant must be present for trial announcement. No interpreter is needed for this defendant, and the defense will rely on the state's file and police reports for witnesses. This is the San Antonio Police Department arresting agency, and the state does not reserve its right to supplement. No motions or pretrial requests will be in, all motions and pretrial requests will be in writing. Motions, and the state has not filed any motions, and neither has this defense in this case, and neither party has any discovery issues or concerns. This defense has received the e-discovery and information. That's correct, defense?
Yes, Your Honor, that's correct.
And you do waive arraignment on behalf of the defendant. No offer has been tendered to this defense on this case.
Correct.
And both the state and defense acknowledge the admonitions and orders of the court.
Yes, Your Honor.
Defendant's email address will be provided to the court coordinator today, the 11th of August, 2022. State, any objections to the court's recitation?
No objection, Your Honor.
Defense,
No objection from defense, Your Honor.
we're off record on that matter. Excuse me. Let us get on record on cause number 678-180. And 678-181. Court calls to order
Your
the
Honor,
matter
if I may,
of State of Texas versus Osvaldo Mora. Party attorneys and attorneys only, please approach and identify who's before the court, starting with the state.
Ling Han for the state.
Victoria Cruz on behalf of Raymond Martinez for the defense. Your Honor, if I may, there is one third misdemeanor case. It is 644-201.
Yes, thank you.
Yes, Your Honor.
Court also calls and includes a cause number 644-201. We're here for pretrial conference hearing today on the 11th of August, 2021. State, please proceed.
This is a just one moment, Judge. I'm not sure what agency this is.
Okay. Defense,
Yes, Your Honor.
are you also on the felony case that's awaiting trial in the 227?
Yes, Your Honor.
You guys are still on the you're in that case. Were any of these cases in connection or out of the same incident with the felony?
112.
Judge, they're not the same incident, but from the notes, it looks like the plea offer in the felony case does contemplate TIC dismissing all three of Mr. Mora's misdemeanors.
Okay.
That's
Alrighty.
correct, Your Honor. And that felony is set for October trial.
What day in October? Do you know?
October 17th.
Perfect.
So the
And it's set for a trial. Yes, it says it's waiting a trial, so it's set for trial. Okay.
October 17th.
Alrighty, we'll reset these cases. Why don't we reset these cases for felony pending for that day? I know you won't know a disposition, but sometime that week, if you do go, please let us know what the possible disposition will be.
Understood, Your Honor. Yes, yes, ma'am.
Does that sound reasonable?
Yes, yes, very much so.
Defense? Excuse me, state. I just talked to the state.
I did earlier too, Judge.
Mhm. That's good. That's good with you. You're okay with that?
Absolutely, Judge. That's fine with me.
Okay, thank you. Alrighty, counsel, do you have anything further in this court?
Not today, Your Honor. I just had those 3 clients.
Thank you very much. And I'm going to put you in a breakout room now with the court coordinator, and thank you. And you owe me pictures.
Yes, Your Honor. He's very cute. He's waking up. Thank you very much, Your Honor. May I be excused from after Miss Luna?
All right, and I'm sure he dresses well.
He does. He does. Thank you, Your Honor.
All
Thank
righty,
you very
let me put your client in the room there, and yes, you and your client will be excused from there. Thank you. David Christian. David Christian, attorney David Christian. Andrew Del Cueto on Robert Polk, Andrew Del Cueto's office.
Judge, this is Taylor. I'm here for that case.
How are we going to dispose of that matter?
We were just going to ask the court, and the state's in agreement with this, for one more pretrial conference. And if you're not inclined to grant that request, then of course, we'll just set it for the trial setting.
Let's get on record on cause number 681-281. State of Texas versus Robert Willie Polk. Attorneys and attorneys only, please approach and identify who's before the court, starting with the state.
I'm sorry, Judge, what was that cause number?
It's 681-218.
Thank you. I'm getting my numbers all mixed up.
Here you.
Okay, I have that pulled up, Judge.
All right, you state if you announce.
This is a San Antonio Police Department case.
Yeah,
And
state I had called the attorneys and attorneys only to please approach and identify who's before the court.
Klingon for the state.
And Taylor Wood for Mr. Polk.
I have Andrew Del Cueto as the attorney of record. Could you please explain to me, Attorney Wood, your relationship to that firm?
Yes, I'm an associate attorney for Mr. Del Cueto's office.
State, please proceed. We're here for a pretrial conference hearing today, the 11th of August, 2022. State, please proceed.
Judge, this is a San Antonio Police Department case. I believe no formal offer has been made, but it has been contemplated by the state and informally conveyed, I guess, to defense.
At defense, do you acknowledge that you have not received an offer conveyed to you orally or in writing from the state?
Yes, Judge.
Yeah. And how are we going to dispose of this matter?
We would request another pretrial conference, I guess a final pretrial conference, and I think the state's in agreement with that. This is a blood draw case where drugs are found, and the state would like to talk with the chemist about the levels of the drugs to see if it could be disposed of before setting it for trial.
That's correct, Your Honor.
So there was no alcohol? Is this a DWI?
It is a DWI, Judge, and it was tested for alcohol, but the result was pretty insignificant.
Sure.
So it was retested for drugs.
Okay, well, keeping that in mind that it is under retest, when are we going to dispose of this trial, of this case, please? The
The-
trial or plea?
The pretrial conference date Marina was able to give me was 9/22. If you would like to just set the matter for trial anyways, then that trial date would be December, well, the trial announcement would be December 1st and the trial date would be December 5th.
Okay. And state, any objections?
No objection to either of those.
Defense, will your client need an interpreter?
No, Judge.
Regarding witnesses, will the defense rely on the state's file and police reports, file a motion, or have the witnesses read onto record now?
We'll rely on the motion being filed, the notice being filed.
Oh, okay, you're going to go ahead and file a motion when? Or did you already file motions?
We've already filed motions, Judge.
Could you give me a date, please?
Yes, they're filed on April 1st, 2022. Looks like they were actually accepted April 4th of 2022.
State, when are you going to respond?
The state will respond by November 8th, 2022.
Defense, is that timely and sufficient?
Yes, Judge.
All motions and pretrial requests will be in writing, especially any that the court needs to arbitrate. Please set those for a hearing on a Friday. State, have you filed any motions in this case?
It has not, Your Honor.
Defense? But besides the motion that you have filed, have you filed any others, and might they be need to be set for a hearing?
Yes, Judge, we have filed other motions and they might need to be set for hearing. We'll have
Okay.
to see.
Okay. Any that you contemplate, suppression, what, discovery?
Probably a motion to suppress and a motion for discovery.
Okay. They were filed around about the same time?
Yes, they were all filed the same day, Judge.
Okay. And when do you want to set the motion for, to suppress? It needs to be on a Friday. You check the calendar.
We need to wait until we hear back from what the state finds out from the chemist. I'm not sure I don't want to waste the court's time in setting that on the docket if the information provided by the chemist warrants not setting it for a motion to suppress.
Mhm. Okay, keeping that in mind, when do you want to go ahead and set the motion to suppress? 2 weeks before trial, 3 weeks before trial, on a Friday?
2 weeks before trial, Judge. We hopefully will hear back from the state before then.
Could you check your calendar and see, give me a date on that, please?
November 17th.
That's for the motion to suppress?
Yes, Judge.
Do you want to cover the motion to suppress and the discovery at the same time?
Please, Judge.
Okay. State,
Judge, that's fine.
all righty. Do you have any discovery concerns or issues, State?
Then on behalf of the state,
Defense?
We need blood discovery and one of the officer's dash cams. It's going to be Officer Salinas's dash cam.
Okay, and are you saying that you filed the standard blood discovery?
We did file our request for the blood discovery with the appendix mirroring the standing order for blood discovery.
Okay. I don't have the files with me at this time. State, are you in receipt?
of the blood discovery,
Right, standard blood discovery, yes.
my understanding is that's readily available, but
The breadth is through this, through the new website that you guys have in the process. I believe this, the breadth is, I'm not too sure about the blood discovery though.
Judge, I honestly am not too sure either.
Mhm.
So I would say no.
So know that you're not in receipt of the order signed by the court?
I do not believe I see anything in the system that's the standing blood discovery order signed by the court.
Okay. Ms. Luna, you have the file. Would you please check that for me? And check as far as that particular motion is concerned, is titled Standard Blood Discovery.
Standard blood discovery?
Right. Attorney,
Yeah, if I may, we did file, it's filed under our request for discovery pursuant to Article 3914, the Texas Code of Criminal Procedure, the United States Constitution, and the Texas Constitution. And on the third page, we reference the blood discovery request in appendix. And if you look at the appendix and you look at the standing order for blood discovery, it's the same. It's just copy and pasted over.
Okay,
So it has not been signed by the court because it was just requested by us as is required by 3914.
when did you request that?
That was back on April 4th of 2022.
No, I would have signed it much earlier. It may have been the way that you packaged it together. That it was, usually that is filed as a standalone document so that it can be signed, and then the state just processes that through. They just take the document and they send it through. But when you package it together, then it kind of gets lost in the shuffle. Would you be able to go ahead and unpackage it so that we can send that and then the state can process it?
I can definitely separate out the appendix portion of the request and send it over.
I appreciate that if you'll go ahead and e-file that so that we'll take care of that matter for you. So you have identified blood draw, the drug test, the standard blood discovery, and then the dash cam of Officer Salinas. State your response to the defense concerns and discovery concerns and issues.
So it's the standing blood discovery and dash cams from,
Officer Salinas.
state is happy to look into that. If defense counsel would be kind enough to please email these also, then I can.
The standard blood discovery will be e-filed. As far as the dash cam for Officer Salinas, will you be ordering that anytime soon?
Yes, Judge, it is also on my list of things to do
Okay.
when we finish docket.
Oh, okay, alrighty. So you'll look into going ahead and ordering that, the dash cam. Today? Tomorrow?
Judge, it largely depends when we get out docket. I anticipate by this week, though.
Okay. I put tomorrow's date. And then defense, you're going to go ahead and separate that out, and the standard blood discovery, when are you going to send that to the court? So we'll be on the lookout for it.
Tomorrow, Judge.
Defense, any other discovery issues or concerns?
Not at this time, Judge.
And have you received your e-discovery
Yes, Judge.
information?
Yes, Judge.
Okay. Are you able to waive arraignment on behalf of this defendant?
Yes, Judge.
Oh, I'm sorry, I asked that in a way that requires a second question. And do you waive arraignment on behalf of this defendant?
Yes.
Okay, thank you. The court admonishes the attorneys to exercise due diligence to ensure that discovery does not impede the execution of trial on the set date of 5 December 2022 and the next court date, and defense to exercise due diligence to notify the defendant of the next court date. The next court date for this defendant will be the 17th of November 2022. for motions to suppress, for hearings on motions to suppress and discovery. And defense, if you don't need those, just go ahead and cancel, just go ahead and cancel out on us, okay? If you don't need those two, those dates to be, those motions to be heard. And then after that, if that is canceled out, then the next will be the trial announcement date of 1 December 2022. If the defendant does accept the state's offer once tendered, defense will tender a jury waiver immediately and set this matter for a plea within 2 to 3 weeks. State, do you acknowledge the court's admonishments and order?
State does acknowledge.
Defense?
Yes, Judge.
Defense, the defendant's email address, is that with the court coordinator, or need to put you in?
I'll
Sorry,
haven't.
go ahead.
I'll chat it to her right now.
Okay. State, anything further on this matter?
Nothing further from the state, Your Honor.
Defense?
Nothing further, Judge.
Subject to your objections, the court understands that cause number 681218, State of Texas versus Robert Willie Polk, will be disposed of by trial on the 5th day of December 2022, with a trial announcement date of 1 December 2022, of which the state has no objections. No interpreter is needed for the defendant. Regarding witnesses, the defense has filed motion for witness list filed on 1 April and accepted on the 4th of April 2022. The state will respond on the 8th of November 2022 or earlier. This is San Antonio Police Department as the arresting agency. All motions and pretrial requests will be in writing. The state has not filed any motions in this case. The defense has filed motions in this case and has set 2 of them for a hearing on the 17th of November 2022. That will be a motion to suppress with a motion to discover, excuse me, a motion for discovery. The state indicated they had no discovery concerns or issues, and this defense identified blood draw and matter of the fact that the blood is being tested for, retested for drugs. Also, this standard blood discovery, they had packaged it together and will unpack it, separate it out, and send it in a separate e-file by tomorrow. So the court will sign that and be able to facilitate the states being able to process that. The defense also identified dash cam of Officer Salinas, and the state is going to order that dash cam tomorrow, the 12th of August 2022. The defense has received the e-discovery as well as the information and does waive arraignment for this defendant. No formal offer has been conveyed to the defense, and the defense and the state acknowledges the court's admonishments and order to the attorneys on this matter. And defendant's email address will be provided to the court coordinator today. State, any objections to court's recitation?
No objections from the state, Your Honor.
Defense?
No objections, Judge.
I'm going to place you in the breakout room with the court coordinator on that, and you are excused. After that, have a great weekend. Thank you so much for being here.
Thank you.
I believe the matter with Attorney Flavio Hernandez is taken care of. Attorney Albert Acevedo, we need to take care of Chelsea Elkins, sir.
Yes, ma'am. I got the dates from the coordinator earlier this morning.
Sir, how are we going to dispose of this matter, plea or trial?
We're going to place it on the trial docket, Your Honor.
Alrighty, and counsel, you won't mind getting a jacket on? Let
Yes,
me go ahead and call the docket, call the case. State, while the defense is coming along, get the cause number 685-032, 685-032, and it's Chelsea Elkins.
I have that case pulled up, Judge.
Okay, defense, you ready?
Yes, Your Honor.
Let us get on record. Call cause number 685-032, State of Texas versus Chelsea Earl Elkins. Parties, please approach and identify who's before the court, starting with the state.
Brett Boses for the state.
Attorney Albert Acevedo for Mr. Chesley Elkins, Your Honor.
And we're here for a trial announcement on the, excuse me, I apologize. Pretrial conference hearing today, the 11th of August, 2022. State, please proceed.
Yes, Judge. This case is from the Chavano Police Department. State and defense have conferred. However, at this time, an offer has not yet been conveyed, I don't believe.
That's correct, Your Honor.
How are we going to dispose of this matter, counsel?
Judge, if I can request a trial date, I received an announcement date for November 17th and a trial date of November 21st.
State has no objection to those days, Judge.
Thank you, state. Ooh. Counsel, will an interpreter be needed for your client?
No, Your Honor.
Regarding witnesses, will the defense rely on the state's file and police reports, file a motion, or have the witnesses read on record at this time?
We'll file a motion, Your Honor, and request that.
And when will that you file that, sir?
We can file that tomorrow.
State, when will you respond?
Judge, we will respond by we'll respond by October 28th, Judge.
Defense, is that timely and sufficient?
And I'd like to get a few more weeks before that, Your Honor.
Defense, state?
What was the trial date again, Judge?
Sir, it was the 21st of November, 2022.
Okay. Judge, I'll make a note here in the file to try to get the witness list sooner, but the state would like to say that we will, at the very latest, send it by the 21st of October, which would be a month prior to trial.
Defense?
That's fine, Your Honor.
That's October, correct?
Yes, Your Honor.
Okay. Okay. State, anything further on witnesses?
Nothing further on that from the state.
All motions and pretrial requests will be in writing. If the defense, if this court needs to arbitrate any, please set it for a hearing on a Friday.
Yes, Your Honor.
Motions and pretrial requests will, excuse me, the state, have you filed any motions in this case?
Not at this time, Judge.
Defense?
The only thing that's awaiting your signature, Your Honor, would be the standing blood discovery order, Your Honor.
Sir, when did you file that?
That was filed I think it was accepted this morning, filed yesterday.
Alrighty, we'll take care of it. Thank you for bringing to the court's attention. Standing blood discovery?
Yes, Your Honor.
Okay. Defense, any other motions filed that may need to be set for a hearing?
Not at the moment, Judge. If I do need to file any, they will be filed and heard, and I'll make sure those are set on Friday.
Okay, sir. Thank you. State, any discovery concerns or issues?
Your Honor, it looks like we're still in the process of getting videos from the law enforcement agency. So I don't have the specifics, but it appears we're missing some videos, and we will be, we've already sent out a request today to get those.
And is that the standard videos, co-band, dash cam, body cam, all of that?
Yes, Judge.
It's specific, Judge, just so I can help you out. It's the body cams that we're missing.
Okay.
We have the co-band, so we're missing the body cams for this one.
Okay. Do you know the officers?
It's Jose Garza. And that would be badge number 401.
Any others, sir?
That's the only one on my list right now, Judge. If there's any others, I'll make sure to tell them.
And defend, excuse me, you're saying that you are ordering those today?
Well, Judge, we sent out a request today, but I'm not sure what the turnaround time will be as it varies from agency to agency.
Yes, understood. Anything further as far as any discovery issues or concerns, state?
Not that I'm aware of.
And defense?
Not at the moment, Your Honor.
Okay, and you have received your e-discovery?
I have, Your Honor.
And have you received your information?
I have, Your Honor.
Do you waive arraignment on behalf of this defendant?
Yes, Your Honor.
The state, the court admonishes the parties to exercise and orders the parties to exercise due diligence to ensure that discovery does not impede the execution of trial. On set date of 21 November 2022, defense to exercise due diligence to ensure that the defendant is notified of the next court date, barring any motions that may be set for a hearing on this matter. The next court date would be the 17th of November 2022 for trial announcement, of which the defendant must be present. If the defendant does accept the state's offer once tendered, then the defense will tender a jury waiver immediately and set this matter out for plea on within 2 to 3 weeks. State, do you acknowledge the course admonishments and orders?
Yes, I do, Judge.
Defense?
Yes, Your Honor.
Defense, the email address for the defendant, have you sent it to court coordinator yet?
Yes, she has it.
Thank you.
I chatted that to her earlier, Your Honor.
Okay. We prefer it by email, sir.
Yes, ma'am. I will go ahead and also email her.
Thank you kindly. Anything further on this matter, state?
No, nothing further from the state, Judge.
Defense?
Nothing further, Your Honor.
Court understands, subject to your objections, that this cause number 685032 is titled State of Texas versus Chesley Errol Elkins will be disposed of by trial on the 21st of November 2020, with a trial announcement on the 17th of November 2020, of which the state has no objections and the defendant must be present for trial announcement on this for trial announcement. No interpreter is needed for this defendant. The defense has filed motions for witnesses, will file it, on the 12th of August 2022, with the state responding by the 21st of October 2022. And has made a note that the defense has requested earlier if possible. The arresting agency is the Chavano Police Department. All motions and pretrial requests will be in writing. The state has not filed any motions in this case. The defense has filed a standard blood discovery. He filed it as of today, the 11th of August 2022. Which the court needs to act on and will act on. Both the state and the issue and the defense, both the state and defense have identified discovery concerns and issues. The state has requested all videos from Chavano Police Department as of today, the August 11, 2022. The defense identified body cams of Officer Jose Garza, badge number 401. The defense has received their e-discovery as well as the information and does waive arraignment on behalf of this defendant. No offer has been conveyed, although the attorneys and parties have conferred, but no offer has been conveyed in this case. The state and defense acknowledge the court's admonitions and order, and the defendant email address will be tendered to the court coordinator via email today. State, any objections to the court's recitation?
No objection from the state.
Defense?
No objections from the defense, Your Honor.
Defense, thank you very much. Do you have anything further in this court today?
Nothing further, Your Honor. Thank you.
Thank you very much. You're excused. Have a great weekend. Attorney Sean Farmer. Okay. Attorney Ivan Barrera. Did you have another matter, sir?
Yes, Judge, I have just one plea. It's a cause number 669901.
I'm in receipt of the plea paperwork. Thank you. As well as the separate data, personal data sheet. Thank you.
Yes, Judge.
Court is going to get on record. Oh, State, can you pull that up? State, can you pull up cause number 669901?
Yes, Judge, I have it.
Excuse me, I'm sorry. Okay, state you're ready to proceed. Defense, you're ready to proceed.
Defense are ready, Your Honor.
State is ready, Your Honor.
Court is calling cause number. Getting on the record and calling cause number 669-901, State of Texas versus Elisa Lizette Flores. Parties, please approach and identify who's before the court, starting with the state.
Ling Han for the state.
Ivan Burr for the defense.
Lizette, excuse me, Elisa Lizette Flores.
Yes, Your Honor.
Please unmute and respond. Okay. Are you Elisa Lizette Flores, the same that has been accused of driving while intoxicated, 0.15 or higher, alleged to have occurred on the 18th day of September 2021 and is classified as a Class A misdemeanor? Are you the same person so accused?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth, under pains and penalties of perjury, so help you God?
Yes, Your Honor.
Thank you very much. Go ahead and lower your right hand. Court is going to start sharing the court screen. Ms. Flores, can you see the court screen?
Yes, I can, Your Honor.
Defense?
Yes, Your Honor.
And state.
Yes, Your Honor.
State, on display is a document entitled State's Consent to Video Conferencing. Did you sign this document that's consenting to these proceedings by video conferencing?
Yes, Your Honor.
State's video conferencing consent is made part of the record. Defense, on display is a document entitled Defendant's Consent to Video Conferencing. Ms. Flores, is this your signature where I am circling the cursor?
Yes, Your Honor.
Did you sign this document thus consenting to plea by video conferencing?
Yes, Your Honor, I did.
And counsel, with your signature on the same document, do you join your client in consenting to these proceedings by video conferencing?
I do, Your Honor.
The defendant's video conferencing consent is made part of the record. Counsel, how long have you been representing Ms. Flores?
Judge, almost a year now.
Are we applying for probation, and if so, what type?
We are, Your Honor. We are applying for deferred adjudication probation.
And Ms. Flores, I draw your attention to the document on display. It's entitled Application for Deferred Adjudication Community Supervision. It is a two-page document. This is the first page, and this is the second page. I draw your attention to where I'm circling in the middle here on the second page. Oh, excuse me. It states that you personally appeared before me today, albeit via Zoom, that you are the defendant in this case, and I have duly sworn you in. And under oath, you're telling me that your application for deferred adjudication community supervision and the document entitled your personal data sheet is true and correct. Now, keep in mind that if your application, if none of these documents are completely filled in, it cannot be true and correct. And I'm going to share with you your personal data sheet. If I can find it. Okay. Ms. Flores, can you see your personal data sheet?
Yes, Your Honor.
Any corrections or that need to be made to it?
No, Your Honor.
Do you need to speak to your attorney to understand the consequences of your response before responding to this statement, that the defendant understands and acknowledges that any untrue statement in the application or in the exhibit that's your personal data sheet may be grounds for denial or revocation of any community supervision in this case? Do you wish to speak to your attorney first?
No, Your Honor. I think we're okay.
Sorry, go ahead.
I think we're okay.
And so your response, do you understand?
Yes, Your Honor.
And you so acknowledge?
Yes, Your Honor.
I will sign the discovery I will sign this document, making it part of the record. State, have you fulfilled your discovery and Brady requirement in this case?
We have, Your Honor.
Counsel, are you satisfied that the state has fulfilled its obligation to provide you discovery under Article 39.14 of the Texas Code of Criminal Procedure, as well as giving you full access to the state's files?
I am satisfied, Your Honor, and states compliant.
And state, is this matter subject to law enforcement disclosure? And if it is, has that been complied with?
Judge, it is subject to and has been complied with.
Thank you, state. Well, I will sign the discovery acknowledgement, making it part of the record. State, do you have any motions for the court's consideration?
Judge, the state has filed or has submitted a motion to amend the information to proceed on
To go ahead and add count number 2?
Yes, Your Honor.
And no objections, Your Honor.
Thank you, defense. State, That motion is with me. State, is this your motion?
Yes, Your Honor.
Defense, do you waive your 10 days to prepare?
We do waive, Your Honor.
Ms. Flores, the information is a document that we use to bring you to court. In it, it describes the offense and the nature of the offense and the charges against you. Anytime that is changed, you get 10 days to prepare. In this case, the state has changed it to add account number 2, and therefore your attorney has waived those 10 days to prepare. Do you join your attorney in waiving those 10 days to prepare?
I am not too sure what was added, Your Honor, but if we discussed it beforehand, yes.
Do you need to speak with the attorney?
Please.
We're going to suspend this record and place the attorney and the defendant in a breakout room to discuss. Attorney Sean Farmer, are you in the waiting room? Hey, how you doing, sir?
I'm here, Your Honor. Doing fine. It's been a crazy day. But
Yeah, tell me about
I was hoping to confer with the state. I believe it was Ms. Han that emailed me, or I emailed, or any ADA.
She's in the middle of a plea right now. ADA Bosis, would you be available to confer?
Yes, I can confer, Judge.
Thank you so much.
Thank you, Your Honor.
Okay, sure. You have got your invitation, sir.
Excuse me, Judge, we're back.
Okay. Let us get back on record. Cause number 669-901, State of Texas versus Alyssa Lisette Flores. Court is going to resume sharing the court screen. At the time that we suspended the record, attorney and the defendant had a question of her attorney and counsel. Are we ready to proceed?
We are, Your Honor.
State, ready to proceed?
Yes, Your Honor.
And it was regarding the state's motion to alter and amend the information to state's written motion to alter and amend the information to add account 2. Defense counsel had waived the 10 days to prepare, and I asked the defendant whether she joins her counsel, her attorney, in waiving the 10 days to prepare. What say ye, Ms. Flores?
Yes, Your Honor.
I will sign it, and so it is ordered. Sorry about this. I don't know why it jumps like that. Okay. So that motion without objections and with the waiver of 10 days has been granted and signed. Ms. Flores, this is now the new motion where there was just account one, that account two has been added. And that state, do you have any other motions for the court's consideration?
Judge, for the purposes of this hearing, the state would move to enter Exhibit 1 for the court's consideration.
No objections, Your Honor.
State, what are we doing with the 0.15 enhancement and count number one?
Those are being waived and abandoned, Your Honor.
Okay. And you're proceeding on count number two, solely on count number two?
Yes, Your
Obstruction?
Honor.
I'm sorry, did you say yes?
Yes, Your Honor.
Sorry, I was talking over you. What say ye defense to state's oral motion to waive and abandon 0.15 enhancement and count number one and proceed solely on count number two, obstruction?
No objections, Your Honor.
Without objection, that oral motion is granted. Now state, you wish this course to you wish to tender the state's Exhibit 1
Yes, Your Honor.
for admission for purposes of this hearing only?
Yes, Your Honor.
Defense?
No objections, Your Honor.
So admitted. Ms. Flores, this is the state's exhibit number 1. It's a package of documents. It includes the waiver of objection to amendment of information and right, stipulation of facts, and judicial confession. The next is a 2-page document of which you and your attorney have signed. The next document is motor vehicles in the household. It indicates here that you hereby swear that you do not own or possess a motor vehicle, and no member of your family or household where you live possesses or owns a motor vehicle. Next is a plea bargain agreement. And the next is a waiver of appeal and post-conviction remedies, which you signed, your attorney signed, and the state has signed. And the next document is an oath whereby states, you personally appear before me today. You are the defendant in this case, and I have sworn you in under oath. You are telling me that all the facts stated in the above stipulations and plea agreement are true and correct, and specifically including these documents so labeled, and I have read to you. I read the labels to you. This is your signature. I am going to sign that, and so making that a matter of record. And here it indicates an order that you intend to plead guilty. I will so order it. And then the rest of exhibit number 1 is police reports and other documents. Okay. State, do you have any other motions for the court's consideration?
No, Your Honor.
Defense, do you have any motions for the court's consideration?
No, Your Honor.
Ms. Flores, I draw your attention to the document entitled Defendant's Waiver of Constitutional Rights and Court's Admonitions. Boy, this thing is so jumpy today. It's a two-page document. This is the first page. And then this is the second page. Is this your signature where I am circling the cursor?
Yes, Your Honor.
Did you go over this document with your attorney?
Yes, Your Honor.
After reviewing it with your attorney, did you freely and voluntarily sign it?
Yes, I did, Your Honor.
So with your signature and testimony, you're telling me that you understand everything in this two-page document as it was explained and reviewed and explained to you by your attorney?
Yes, Your Honor. I
Are
did.
you good? Are you satisfied with the representation of your attorney?
Yes, Your Honor.
An excellent attorney, and he has done very, very well by you. He has not only removed the DWI on this, but then he has also removed the enhancement, the 0.15 enhancement, got the state to lower this to an obstruction of highway, and furthermore, has been able to make it a regular DWI, a regular Class B misdemeanor. He explained to you then the range of punishment with the new case, with the new offense.
Yes, Your Honor.
And also you understood your constitutional rights.
I do.
And after, with that understanding, Ms. Flores, do you freely and voluntarily give up your constitutional rights?
Yes, Your
Are you a U.S. citizen?
Yes.
I will approve your jury waiver and sign here, signing the document. You will no longer be able to have a trial in this case, as I have made it matter of record. Counsel, do you believe that your client is competent to enter into a plea today?
She is, Your Honor.
And with the amended information, were you able to apprise this defendant of the nature of the offense and charges against her?
I was, Your Honor.
And do you and the defendant waive the formal reading of the amended information?
We do waive.
State, what is your punishment recommendation?
The state's punishment recommendation is for a $250 fine and court costs, 18 months deferred adjudication, 24 hours community service restitution, DWI education.
Hang on 2 seconds. I'm sorry. How long on the CSR, the community service restitution?
24 hours, Your Honor.
Thank you.
DWI education, U-Impact panel. I'm sorry, uimpact.com. ATP evaluation and the recommendations from it. Ignition interlock for half term.
Counsel, is that your understanding of the state's punishment recommendation to the court?
It is, Your Honor.
Ms. Flores, is that your understanding of what your attorney has worked out with the state on your behalf in order to result, to be able to dispose of this matter for you today?
Yes, Your Honor.
With that understanding, how do you wish to plead? Guilty, not guilty, or no contest?
Guilty.
You're pleading guilty because you are guilty and for no other reason than the fact that you are guilty?
Yes, Your Honor.
Okay. Thank you. State, we have a little bit of difference, and defense, we have a little bit of difference on the documents. Let's see if we can correct and reconcile it. The obstruction document said guilty, of which I've clicked and ordered on, and the defendant has pled guilty, but in the courts constitution, the defendant's constitutional waiver and court's admonitions, it indicates a plea of nolo contendere. State or defense?
Yes, Your Honor, I can address that. I did advise my client about the state's policy on pleading guilty when it's an obstruction, and she's in agreement. That's fine. We can proceed with a guilty plea.
State?
No objection, Your Honor.
So, State, do I have your permission to make a pen and ink change to this document so then it will match up with all the other documents and the police?
Yes, Your Honor.
Defense, do I have your permission to do the same?
Yes, Your Honor.
Thank you. Defense, what, if anything, do you have on behalf of your client?
Yes, Judge. My client wanted me to let the court know that this whole entire experience has been traumatizing. She never wants to be in this situation again. She wants to do better, not just for herself, but for her child. Is asking the court for a second chance because she knows she can do some good in the community. She is a single mom, working full-time, taking care of a child. Other than this case, she has no other criminal history, Your Honor.
Ms. Flores, whom do you live with?
By myself, just my child and I.
And your child, how old is your child?
He's 4.
Do you have the ignition interlock in your vehicle at this time?
I do not own a vehicle at this time.
Infinity of San Antonio, is that a car place?
Yes, ma'am, it is.
Okay, and you say that you work in customer service?
At the service department.
Okay, do you have to operate any of their vehicles?
No, Your Honor.
Okay. And the wages that you have indicated, is that daily, weekly?
That is
bi-week-
weekly.
That's weekly?
Yes, Your Honor. Mm-hmm.
State, what is BAC in this case?
Judge, the BAC was a 0.15.
Was there an accident?
There was an incident on a train track, but we have not had any restitution requests.
Would that be by the city of San Antonio?
I believe it'd be Union Pacific.
You're here.
Yeah. Get that card. We need to cash out real quick. All right. All right. Right this second.
Defense, is there any legal reason why why this matter cannot be disposed of today?
No, Your Honor.
Ms. Flores, although there is sufficient evidence to find you guilty in this case, I'm going to withhold my finding of guilt, and I'm going to place you on 18 months of deferred adjudication, community supervision, probation to for obstruction of highway. You will be monitored and supervised by the community supervision and corrections department on behalf of this court with the following conditions: a $200 fine plus court costs, 24 hours of community service restitution, DWI education, uimpact.com, TAP evaluation, and parenting class. You'll install an ignition interlock and maintain it for half the term, and it'll get installed within 30 days. While in the interim, you will be submitting to weekly UAs until a device is installed. And that would be to include ETG, ETS. I'm going to require 2 affidavits from you, and it can basically be really on one document, but one that you will not drive any vehicle that's not equipped with an ignition interlock. You have indicated here that you do not own a vehicle, so I will require the affidavit that states that you do not own a vehicle and you will not be driving. You will provide a status of what happened with the vehicle that's included in this incident. That was involved in this incident. And ma'am, the thing is, if the vehicle was towed away and has something else has happened to it, or it's in the mechanic shop, I will need a third-party verification. I will also need the ownership to identify the owner of the vehicle, your relationship to that owner, and I will require that vehicle to be identified by year, make, model, color, and license plate, and the last 6 digits of the vehicle identification number. I will also order restitution, if any, to Union Pacific to be determined by the Community Service and Corrections Department. Defense, you can request a restitution hearing by filing a motion and setting it for a hearing on a Friday. And I'm going to set your supervision fee at $35. State, have I covered everything for you?
Yes, Your Honor, you have.
Defense, anything further on this matter?
Judge, just two things. The first thing is, so the defense will reserve its right to restitution hearing if
Yes, sir.
if needed. And then the second thing, Judge, is so she doesn't have a vehicle. Once she provides affidavits stating that she doesn't own a vehicle, will not drive one, third-party verification and third owner, I guess for verification as well. Will she be permitted to obtain the portable device, Pam?
And she should communicate all of that with her probation officer, and they will submit something to me. That's why I'm giving her 30 days instead of my usual 10 days.
Understood.
Yes, sir, absolutely. Until the device is installed. Yes, sir.
Understood, Your Honor. And nothing further from me, Your Honor.
Okay, we'll go ahead and get those UA set up. Now, Ms. Flores, with regard to the trial court certification of defendant's right to appeal, this has been a plea bargain case, and I am going to certify that you have no right to appeal. Now, you'll be able to get a copy of this document when you come to provide us the your fingerprints. Will you be able to do that today, Friday, which is tomorrow, Monday, Tuesday, or Wednesday? Which will work for you?
Wednesday.
Wednesday, okay, great. Wednesday is the 17th of August. Ms. Flores, you will be coming down to County Court at Law Number 2, located at 300 De La Rosa, San Antonio, Texas, 78205. You'll be coming down to see us. We're located on the first floor of the Kadena Center, Kadena Reeves Justice Center, between the hours of 2 p.m. after 2 p.m. and before 4:30 p.m. When you come, you report to the deputy, and the deputy will go ahead and give you further directions on that. Now, understand that if you do not show up on the 17th of August, 2022, that a warrant will be issued for your arrest. Do you understand that?
Yes, Your Honor.
Very well. Now, Ms. Flores, your attorney said a lot of nice things about you, and you know that he worked very, very hard for you. The way for you to show your real appreciation of the hard work your attorney has done for you is for you to be successful on probation. I want you to be successful on probation. I'm looking forward to it. And I have no doubt that you probably will be. 18 months, though, is a long time to be under any kind of a scrutiny. So if there's anything that the court can be able to assist you with in being successful and while on probation, please make sure that you communicate that to your probation officer, CSO, and of course you have the very fine attorney to be able to turn to as well. Any questions?
No, Your Honor.
Well, thank you so much for being here and taking care of this matter. I appreciate it. Counsel, anything further in this court today?
Nothing further, Your Honor.
All righty. And thank you very much. We're off record on this matter. You have a great, you have nothing further. You have yourself a great weekend, and we'll see you on Wednesday, Ms. Flores.
Thank you. You too.
All righty.
Thank you, Judge.
Thank you.
Thanks, State.
Thanks. You too. Attorney Farmer.
Hello, Your Honor. I do have conditional dismissal offers for my case for Miguel Garcia under 685-461. And I would like to convey these offers to my client. So I request a date for either another pretrial setting date or a plea date, Your Honor.
Miguel Garcia?
He's not present, Your Honor.
Oh, he was present in the courtroom. He did answer the docket. Deputy, did he not come back? There he is. Is that Mr. Garcia? You can take your hands out of your pocket, sir. Is that you, Mr. Garcia? Yeah. Does he have the microphone? Because we can't hear him. Is that you, Mr. Garcia?
Yes, Magistrate, it's Miguel Garcia.
Okay, not a problem. Counsel, do you need to speak with your client a minute before we get on record?
I do, Your Honor, because I have 3 phone numbers for him and I just tried them all and they have been unable to get a hold of him. So if I can get a working phone number from him, that would be helpful.
Okay, let me go ahead and do that. Put you guys in a breakout room to be able to. Deputy, could you go ahead and set Mr. Garcia up in the computer in the back room, please?
Yes, ma'am.
And Your Honor, we still have a David Ibarra in the courtroom.
Okay. He needs to call his attorney. I don't see his attorney on the Zoom hearing anymore.
Yes, ma'am.
Yes, this is David Ibarra. I'm in the courtroom right now. They're just asking for Jose Rocha to get back on Zoom for court number 2. David Ibarra. Cause I'm in, I'm right now.
Attorney Rocha, you're back. Thank you so much for your patience. Now we have Mr. Ibarra. Mr. Ibarra, would you please step up to the mic where the table is? Give him a minute. The deputy is getting someone else set up. Deputy, could you bring Mr. Ibarra over to the prosecutor's table?
Yes.
And he has a mic.
Yes, ma'am.
Alrighty, getting back on record. I think this is number 10 and no, let me find it. Counsel, will you be able to help me with the cause number in this case, please?
It's number 15, Judge.
Number 15, oops. Okay, thank you. Get back on record on cause number 652. Excuse me, 652-322. The court calls that matter of State of Texas versus David Ybarra to the bench to parties, please approach and identify who's before the court, starting with the state.
Brett Boses for the state.
Defense,
Jose Rocha for David Ibarra.
and you, David Ibarra?
Yes, I am.
Okay, alrighty. At the time that we had addressed this a couple of matters earlier. One was a motion to withdraw, and one was a motion for continuance. And so I had asked defense if you would, with regard to supporting your motion for continuance, if you had consulted local rules.
Your Honor, I did consult local rules, and during this time, since we did get here at 8:30 and independency, I did attend the first hearing for preliminary matters on the August 15 jury trial, which now has been called onto the record with Judge Salinas in the 166th. And we're still set, and we're officially now in trial. So evidence will start on Monday morning. At
Okay.
some point Monday.
So
And
you
in
are,
terms of my motion to withdraw, Your Honor, it continues to be the same. My client has stated on the record that he does not wishes for me to represent him anymore, that he wants another court-appointed attorney to be appointed to him so that he can have justice, Your Honor.
and so you stating with regard to the motion for continuance that you are definitely set. You're saying that the case has already been called to trial.
Your Honor, I asked specifically Judge Salinas that if any court or any judge needs to confirm that I am set and that this case is moving forward on Monday, she stated that they can check with that court. And in fact, if that's what the court would like to do, we had a hearing today at 1:30, Your Honor.
Okay, alrighty. So, and what does the local rule say?
Your Honor, I'm guessing you're gonna be following the local rules.
No, I'm asking you what it states. I do appreciate the fact that you're trying to read my mind, but could you answer the question? What does the local rule say?
Your Honor, it depends on which section of the local rules and on to what matter. But Your Honor, if you, whatever, I don't know what decision you're gonna be making, but right now, I'm guessing that the court will need to address the fact that my client has stated on the record that he does not want to be represented by me, and that the state has also not objected to the motion to withdraw and did advise the court that they don't believe that it would be in the best interest of the client and justice and the community for us to move forward with a case where a defendant does not want to be represented by counsel. His counsel was appointed by, I was appointed by this court, Your Honor. He is indigent. He has been here all day. And I don't believe that it would be in the best interest of justice, the community, or any type of criminal justice system to allow for a person to go to trial with a counsel that he is not wanting to be represented.
And what does the local rule say with regard to priority of matters between criminal and civil matters?
Well, it has nothing, that whatever the local rules say about the motion to withdraw is up to your discretion, Your Honor.
I'm asking with motion for continuance because you say you're set for a civil matter on Monday. What does the
Yes,
local
Your
rule
Honor.
say?
What specifically would you like me to answer, Your Honor?
Yes.
What specifically would you like me to answer?
I have asked a question very specifically, so allow me to go ahead and see if I can be more concise with it.
I would prefer that the court make a ruling, Your Honor. That is for your discretion and your determination to make.
what
But I'm
does the
telling you what it is. I have filed my motions. I have made my statements, Your Honor. I have been communicating with the court. You had me waiting from 8:30 all the way till 4:54 right now. That is the time currently, Your Honor. If you would like me to attend and come and show up on Monday, then I will do so. But I don't believe that I need to be questioned at this time on the local rules.
So you said you consulted the local rules, correct, sir?
Yes, Your Honor, I did.
And with regard to the priority between criminal and civil cases, what does the local rules state?
What you have stated before, Your Honor, that criminal matters have precedence if they haven't been set yet.
So that if it has not been set yet, and you're saying that you're set in the
If the court would like to correct me, you can correct me, Your Honor. But
no, I'm just making emphasis because it says that the court's understanding is under local rules, the criminal matters take precedence over civil matters. But you're saying that the local rules are saying if the matter has not been set. So that supports your argument, sir, that you are already set for a trial at a district level in civil.
yes, Your Honor, and it's been set for months.
Okay.
And we advise your court that there was a conflict at the time that we got notice of the hearing date. That same day, within hours, we let the court know that there is a conflict from a previously set jury trial, Your Honor.
And as you can appreciate, trials are set. However, that doesn't mean that you're actually going to go into trial. But you're saying that with this one, this is specially set, basically to effectively specially set, and you're going to be in trial on Monday.
Yes, Your Honor. And if the court would like to confirm my attendance on today's hearing at 1:30 with Judge Salinas and the setting, which I already sent the notification from Ms. Dossman stating that the case was set for August the 15th, the court may verify that information.
Your motion to withdraw is denied. And the court will go ahead and consider your motion for continuance. And see whether you are in trial on Monday, sir. Taking evidence on Monday. Okay?
All right, Your Honor. So just so that we're clear, my client's constitutional rights are being trampled. He is not being able to have counsel of his choice, that even though there's been issues regarding him wanting to be represented by me, you're wanting counsel, meaning me, to move forward on a trial when the client does not want to be represented by me.
If he wishes to go ahead and get an attorney of his choice, of which he is constitutionally is his constitutional right. He may go ahead and proceed. But we'll see that attorney, if you wish to go ahead and hire an attorney, we'll see him, see that attorney with a notice of appearance. Otherwise, your motion to withdraw is denied.
Okay, so if he hires an attorney, I just want to make sure that he understands, because he's there, Your Honor. An indigent defendant, if he's able to hire an attorney, then that would be okay. However, the fact that he does not want to be represented by me is not enough for this court to allow me to withdraw.
You are instructing your client?
I'm asking you a question, Your Honor, respectfully.
Oh, sure. If that's instruction to your client, that he understands that he needs to go ahead and has the right to acquire an attorney of his choice, he can go ahead and do that.
Okay, but what I'm asking you, Your Honor, is that him being indigent, because this court found him to be indigent, whether then at this point in time, even though he does not want to be represented by me, the court is not willing to give him another court-appointed attorney, he needs to go find somebody and pay for somebody to represent him.
He has the right to have an attorney of his choice. And if he wishes to go ahead and do that, otherwise your motion for withdrawal is denied. Anything further on this matter, state.
Nothing further from the state, Your Honor.
Anything further from this matter, defense?
Yes, Your Honor. I would like more clarification on the motion to continue.
Denied.
Hold on. You have just granted it and now it's denied?
The motion for continue, I said that
Yes, Your Honor.
I would consider that on Monday.
So you're gonna consider it at what time on Monday, Your Honor?
When you're in trial, if you see your turn trial.
Okay. Would it be easier if the district court judge sends you a note regarding that setting?
That's not necessary, sir. When you're in trial, we will go ahead and be able to determine that. I think it'll be obvious.
Okay. At what time will you need me to be in court then on Monday representing a person that does not want to be represented by me?
Actually, the jurors come in on Tuesday. And we get the jurors on Tuesday. And right about 12:30, you need to be here. The state parties need to be here by 11:30 a.m. on Tuesday.
Your Honor, so my setting is for Monday, but you're not having court until Tuesday?
The jurors. And it's well known that we are scheduled jurors. We're scheduled jurors. And so my schedule when I acquired attorney jurors is Tuesday afternoons. So
Your Honor,
Tuesday
but the setting
afternoon-
was for Monday. At what time do you need me Monday? It's not well known. It's actually very confusing, Your Honor.
Oh, okay.
I need to know, when do you need me and my client on Monday? Because that's what the setting said.
Mhm. The setting, what we do is when you ask for a trial setting, we go ahead and have the trial announcement on a Thursday, and we have just been carrying on with Mondays. The reason being is that that's what we were doing, and it's just so much easier to be able to go ahead and determine that. But with the changes with COVID, with the situation it is, I get jurors on Tuesday. So I would like for you to be here 11:30 a.m. Tuesday with your client in person, and we shall proceed.
11:30 on Tuesday.
Yes, sir.
Okay, so there's gonna be another order reflecting such because my client is out on bond?
Yes, sir. Order as far as a court.
Just a court order stating the time, date, and place to which both defendant and his counsel needs to appear.
Yeah.
Because I was given a date of Monday.
So, yes, a case setting form is going to be provided to your, to you and to the defendant.
Okay, and that's gonna be provided today?
Yes, he's there. My court coordinator is gonna provide one to him in writing, so he can take it with him and probably email one to you, sir.
Excuse
Or
me,
he can go ahead and have it and email it, or he can take both copies and provide you a copy, sir.
Okay, so
Either way, you're
11:30
going
on
to,
Tuesday, I will wait for your setting to be sent, Your Honor.
okay, alrighty, sir. Alrighty, nothing further?
I believe that somebody wanted to intervene. I don't know if it was Mr. Bosis or somebody else.
Anything further on this matter? Alrighty, okay, counsel.
Oh, yes, Your Honor. I had to work on Tuesday. I've been missing a lot of work. And then Mondays I'm off. Sundays and Mondays are the days that I have off. Is there a possibility I could get like a court date for like a Monday? Because I've been missing so much work and then I'm getting close to getting fired as well.
Sir, that's, you'll get a setting for Tuesday at 11:30. See you then. Thank you.
So the answer to my client's question is no, correct, Your Honor?
The setting is for Tuesday at 11:30.
So it's no, Your Honor,
No, to what?
to the question that my client is asking.
I think I've answered it. Yes, I have answered it. If there's nothing further,
Can
then.
he be excused then for the day?
Oh, as soon as the court coordinator gives him a piece of paper, so he knows the case setting days, he usually gets 2 copies. He can provide it to you, and the court coordinator will send you a setting unless you want to come down if you're close enough to go ahead and pick up that copy.
No, Your Honor, thank you.
Okay.
I will wait for your court coordinator to send me a different date than the date that was originally given by the court, which was Monday, August the 15th.
I appreciate your understanding and cooperation. If there'd
Likewise,
be
Your Honor.
nothing further, we're off record on this matter. Attorney Sean Farmer, are you ready to proceed with your client?
Yes, Your Honor. My client would like to accept the offer. It's for a conditional dismissal. So I'm uncertain. I guess he does not fill out plea paperwork for it, but I
Okay,
guess to have a recent date so that he may pay the fine. That is,
Okay, Attorney Farmer. Let's go ahead and get it on record on cause number 685461. State of Texas versus Miguel Garcia. Miguel Florencio, is he here?
Yes, Your Honor.
Okay, Florencio Garcia.
Florencio, yes, ma'am.
Florencio, thank you. And let the parties approach and identify who's before the court, starting with the state.
Brett Bosis for the state.
And
Sean Farmer for the defense.
and you are Miguel Florencio Garcia.
Junior, yes, ma'am.
Junior, thank you. And okay, let the record reflect that the defendant is in this court session with his attorney. We're set for pretrial conference hearing today, but counsel, you have indicated that the state has tendered to you or a conditional dismissal offer.
Yes, Your Honor.
State, what is the conditions?
Good. He can either do 24 hours of community service, or he may make a $250 donation to the San Antonio Food Bank.
So either or.
That's correct, Judge.
Okay. And defense, which one is it going to be?
He would like to make the payment, Your Honor. However, he has mentioned that he is having some sort of financial hardship right now and would need a little bit of time to come up with the funds.
Why doesn't he perform the community service?
He mentioned that he has health issues, Your Honor. I believe it was arthritis and some other conditions, Your Honor.
I do have doctors that can, agree. You can either ask them, they're there. Your Honor, on the community service, was it saying to do, I can't be outside too long because I take high blood pressure medicine and it throws me off with the heat. I do have arthritis all over my body. I can work some.
Sir, you have a choice between 24 hours of community service and donating $250 to San Antonio Food Bank. Counsel, so you have chosen the $250?
Yes,
Your
ma'am.
Honor.
Okay, all righty. All right, now counsel, you understand that I have alternatives by which the community service hours can be completed, satisfied, and I'm not too sure where it's getting the idea of having to work outside. There's different agencies such as Goodwill that he could be able to go ahead and perform those services. Did you want to consult with the court? Well, the court liaison officer is gone for the day, so counsel, how much time does he need to perform his selection of $250? The state is being very generous in giving a choice, giving the conditional dismissal and then giving a choice.
I believe he had mentioned before that he would be able to put a certain amount. I believe 30 days.
And do you have a date? Sure. Do you have a date that works with that 30 days?
believe
No,
it
I
would
can't
be-
hear.
I believe it would be September 8th.
The 8th of September?
Yes, Your Honor.
Is this, Deputy, is this, can you hear me?
Yes.
Okay, is there something wrong with the,
It's me, it's my hearing.
It's just his hearing.
okay. I asked your attorney, sir, for a date by which you will complete the requirements for to pay $250, make a $250 donation to San Antonio Food Bank. He tells me the 8th of September.
I need a little bit more lenient time, Your Honor. I'm getting close to getting evicted from my apartment, Your Honor. And I don't really have anywhere to go. I have no family here. And I was wondering maybe if you could, maybe to the end of September to come up with that money? Like towards the end of the last week of September, maybe? Is there any way you can help me out with that?
I will give you to the 23rd of September.
That's fine. That's some leeway there. Thank you, Your Honor.
Now, understand, counsel, that if he does not complete that requirement on or before the 23rd of September, and I don't get a dismissal with proof of completion, that he will have to plea on that date.
Yes, Your Honor.
Okay, all right. Do you want me to just shift that over the weekend to the 26th, counsel? Do you think that'll?
Yes, please, Your Honor.
Okay, so let's go ahead and reset for that on the 26th of September. This must be completed or plea on that date. Do you understand that, Mr. Garcia?
What I'm understanding is that I have to pay monies, yes, but do I still have to do community service as well? Is that what you're saying to me?
your attorney will explain all that to you, okay? Because we've gone through that already, okay?
Okay.
Anything else?
No, thank you, Your Honor.
Okay, excellent. So we're on the 26th of September. Thank you.
Yes, Your
May I
Honor.
be excused?
Okay, you may be excused, counsel. I need to put you in the court, in with the court coordinator to be able to make sure that we have all the information, and she'll give him a reset form, okay?
Okay, thank you.
Thank you so much, sir. Appreciate your time and good work on that. Okay, let's get him in that back in that breakout room. Let me put him in with the court coordinator and we'll get him all set up, okay? Have a great weekend. State, I think that covers everything that will require your attention this afternoon. Thank you so much for your time.
Thank you, Judge. See you tomorrow.
Okay.
Hope you feel better.
Thanks a lot. I appreciate it.
Have a good day.
Have a good day too. You guys are excused.
Thanks.
Thanks. So are you leave? Oh, Mr. Boses.
Judge, what is Mr. Farmer client coming in for? Sorry, I was.
Sure. Make sure that you have his email address, the whole 9 yards, and then make sure that you give him a case setting form and provide that to also Attorney Farmer.
What date did you give him for the condition of dismissal?
26 September.
Okay, I'll go ahead and give him a case setting form right now.
Thank you. Mr. There's a Joshua Geltman, Wilshire Woods. If you would place your device on a flat surface and place yourself in the center of it, I'd be appreciative. Thank you very much. And Mr. Robert Williams, I'll need a video, please. Okay, at a time that I spoke with you earlier, you said you're going to take 10 minutes on this matter. And I am going to hold you to it. Okay?
Okay.
All righty, you've got 10 minutes. Let me call the matter. We're going to get a record. The court is going to call cause number 2022 CV 02474 Wilshire Woods versus Robert Williams. Parties, please approach and identify yourselves for the record. State your name and the fact whether you're a defendant or a plaintiff in this case.
Wilshire Woods, plaintiff Joshua Geltman representing Wilshire Woods.
Mr. Williams, you'll need to get in a better position. I cannot see you. The light is behind you, should be in front of you, sir. The same result. Moving it closer doesn't help. The light needs to be in front of your face, not the other way around, sir. It's behind you. Now you just have your back of your head to me. Sir, I need for you to place the device on a flat surface and place yourself in. I know some folks are not too familiar with cameras, but if the light is coming through to the camera, it will better light your face, sir. While Mr. Williams sorts himself out, Joshua Geltman, are you an attorney?
No.
You are the plaintiff in this case, you're saying?
Yes.
And is the style of the case Wilshire Woods, period?
Wilshire Woods versus Robert Williams.
What is the style? What is the name? Wilshire Woods? Is it Wilshire Woods?
Yeah,
Plaintiff,
2
or is
words.
it-
2 words, Wilshire Woods.
Okay. Okay, Mr. Williams, are you ready to proceed? Please unmute.
Yes, ma'am. Is that better?
It will work at this time, sir. Okay, so you are the defendant in this case. This is a eviction appeal case, and you are both representing yourselves. Is that correct?
Yeah.
Yes, ma'am.
What is Wilshire Woods? Is it a company, LLC?
Apartment
What is it?
complex. Apartment complex.
It's an apartment complex, and what is your role with the relationship with the apartment complex, sir?
The manager.
You are a property manager. And it's going to work real well, Mr. Geltman, if you let me finish my question before you answer, okay? Because the court reporter can only hear one voice at a time. Okay. All right. So your motion, you are the, although that you are the plaintiff in this case, Mr. Woods, Mr. Williams is the pro se who has done the eviction appeal.
Correct.
Is that correct? Okay, Mr. Williams, what are your concerns? What's going on? Tell me.
Okay, Your Honor. I was, prior to moving out, I was how does this go? I moved out officially on the 30th of June, and it was said that I was given this paper of the balance once I finished the first court hearing. I had to pay the court $875, which is the original rent, and I had a balance of $1,974 due to avoid collections. Now, in between all of this, when I signed my lease, they said that well, in the lease, it says that it would be taken up in, hold on, I'm sorry, Your Honor, 1 second.
Okay.
It is, I'm trying to read this. It would be filed out at collections with Phoenix Discovery by Miss Lynn, who I've spoken with, and she sent me some documents, and it was stating that prior to the balance that I just quoted, it would be a reletting fee, and I don't understand why. It would also be, and it would increase the balance to $3,639.61. And also, I was trying to keep this from going on my leasing record. Because they said if I would have everything moved out by June, and it would keep it from going on an eviction record.
But it already got sent.
But it already got sent to it. It had already been sent to collections the following week. And also, I'm sorry, Your Honor. Also, the date that on the 30th, when I went to go turn in the keys and showed that I had cleaned the apartment and cleared out everything, I normally pay my rent through this app called Portal, which is the app signed by the apartment complex. And the manager at the time, she said that I would no longer be paying through the app, but through money order or through the court.
Okay, so you said you moved out on the 30th of June. I just want to make sure I understand this. On the 30th of June?
Yes, ma'am.
You did what you're supposed to do, turned the keys in, and cleaned up the apartment, right?
Yes, ma'am.
Okay, that happened on the 30th of June. All right, now you say that rent is a monthly amount of $875?
Yes, ma'am. Yes, Your Honor.
And then you said there's some balance due is 1,900 and what?
It was $1,974 due after the $875 was paid to the court. Yes, ma'am. And now I don't understand why it would be so high, $875 for 2 months. It was only, I paid the month of May that for the to the court, and I was only the past due of wait, how much? Excuse me.
But the amount is in collections is.
The amount that, yeah, the amount that they sent to the courts is like double or triple what I was supposed to have been paying.
Sure. You said there's a balance of $1,974.
Yes.
You paid May rent of $875, and you paid that into the court registry.
Yes.
And you said that that if you pay the balance of 1,974, that you understood that that would avoid collections.
Yes. And would not go on my leasing record.
Okay. And now
to collections. I'm sorry, Your Honor. I'm so sorry.
Court report, if you want to make a record, the court reporter can only hear one voice. I can
Yes,
only
ma'am.
hear one voice. So
Yes, ma'am.
the so when did you have this understanding? When did you understand all this? What date was all this spoken about or deal made, and do you have it in writing?
Okay, this is the paper. I've received this one before the 30th before turning in the key. This was on my door for Wilshire Woods apartment. Current balance $2,849 minus $875 paid to court, equaling $1,974 due to avoid collections. Move out date 6/30/2022. Thank you for your cooperation, Wilshire Woods. And
okay, what's the date on the letter is what I asked, sir.
it's no date, ma'am. It was just taped to my door on the apartment door.
When did you notice it? What date?
Before I moved out. I'm not specific on the date. It was somewhere between the 22nd and the 30th.
Of what month?
Of June.
Between what dates?
The 22nd and the 30th.
Okay, then you said that you got information concerning a reletting fee in the amount of how much?
Yes, ma'am.
3,000
Yes,
something?
Your Honor. Yeah, $3,639.61.
Okay, and that's the reletting fee? Are you saying there's the reletting fee is $3,639.61? That's your understanding of how much the reletting fee is, or is there other fees involved in that amount?
No, ma'am. I'm sorry. That's the total that's sent to collections.
Okay, and so so what about the reletting fee? You say that, so the total amount of $3,639.61 is the amount that was sent to collections. And you
Yes.
said it included a reletting fee. Is that what you're understanding?
That's included in the total of $3,639.61. The reletting fee is included in that.
And your understanding of when that was sent to collections was when? What date?
The date on the paper was 7/7.
The date
I'm
on
sorry,
the
is there
paper was-
somebody in here? Is there somebody else on here? Because the court reporter takes down the voice of everybody who speaks.
ma'am.
I am on record. So is there somebody else
ma'am.
involved in this party?
Yes, ma'am.
Okay. Is that person, is that a person who's a witness for you?
Yes, ma'am.
Alrighty. So what I call to say, if you have any witnesses, that's the time that the person can speak, and they speak in response to your questions.
Yes, ma'am. I apologize.
Okay. So when it was it your understanding that that your record was sent to collections?
On the 7/7/2022.
Okay, then you also said something that you did not wish to for this matter to appear on your eviction record.
Yes, ma'am.
Okay, so was there where did you understand that that might not appear on your eviction record?
In this first paper where it was saying that current balance of after paying the $875 to the court, the balance being $1974 due to avoid collections.
Okay, so did you pay the $1974?
No, Your Honor, I haven't paid anything. I was waiting on the court date of today because they said I couldn't do anything through the portfolio app. And then when the collection thing came, I'm like, I just have to wait it out till court because the collections lady was saying that I can do payments and installments, and I didn't understand how I would be doing installments if I was already having a court date and my balance was another number.
So you didn't understand the numbers?
No, Your Honor.
Okay. All right. Now you said something as far as so your understanding is that piece of paper with no date on it that it says to avoid collections that you needed to pay $1,974. Is that your understanding? And did you get instructions on there where to pay that $1,974?
No, Your Honor. She told me.
Did you get instructions on the document where to pay that?
No, Your Honor.
Okay. You have, as far as you also said something about being able to pay your rent. You said something about a money order to the court. Could you kind of put that together in a sentence for me?
Yes. Oh, I'm sorry.
Go ahead.
I apologize again. Jumping the gun.
Sir, can you respond? Do you understand my question?
Yes, Your Honor.
Okay.
It wasn't to the court. As I was going into turning my keys on the 30th of June, I spoke with the manager on duty, and I was asking her, I was turning in my gate key, my mailbox key, and the apartment keys, and every other thing that was in the checklist. And I asked her how would I be paying still through the portfolio? Would I still be paying through the portfolio? And she said no, it would be through the Dropbox in the office, through money order or check.
Okay, so she verbally on the 30th explained to you that you needed to go ahead and place a money order in the Dropbox.
Yes, Your Honor.
Okay, and whom did you speak with?
Oh, shoot. What is her name? It's the manager of Wilshire Awards. It's Glenda. Because I've rarely seen her. It was normally a guy at the desk, and I need my list to get the names. I'm not familiar with her name just right off, Your Honor. The manager, Joshua, should have her name because it was only those two.
Now, sir, what did you understand that you needed to pay by money order into a Dropbox?
Their remaining balance.
Then $1,974.
Yes, Your Honor.
Okay. All righty. And were you given a certain time on that documentation that you have that $1,974 needs to be paid by? Deadline?
No, Your Honor.
Okay, Mr. Williams, do you need to call your witness?
No, Your Honor.
Huh?
No, Your Honor.
You don't want to call your witness?
No, Your Honor. They were just here with papers that helping me with the papers, passing them to me. So I had a lot in front of me in a small.
Okay. All righty. Wilshire Woods, Mr. Joshua Geltman.
Yeah.
Do you go ahead? Are you done for right now, Mr. Williams?
Yes, Your Honor.
Okay. Mr. Geltman, plaintiff. Proceed, sir.
It's essentially what was said. We were short $425 rent in April, $875 rent in May, and $875 rent eventually in June. We got judgment at the JP in May. However, he did wind up staying till June 30th. That's why he also owed June's rent. The reletting fee is charged for failure to fulfill the lease. That's a 85% charge of 1 month's rent for not paying the balance on the lease. He was given the option to avoid the collections if he was able to pay the remaining balance by his move out. And we didn't receive any further payments except for we were made aware of the $875 paid into the registry. Basically, we're looking for I believe you have the paperwork for a motion to release the funds on the $875. We'd like to at least recapture that at this time. As far as his remaining balance with the collections, try and work out either a payment arrangement or he can try and work out a settlement if he has a lump sum he would like to offer as a settlement to avoid the larger charge. They may be willing to listen to that. But he has moved out. We already have possession of the unit. So we're really just trying to get the judgment for what's currently owed and then the release of the funds.
So you said he was short in rent. What month?
April $425, May $875.
Hang on a second.
Okay.
I'm not my court reporter.
No problem.
And May, how much?
875,
Mhm.
and June 875. And this doesn't include any late charges, which is normally 10% of each month's rent, which would be 8750 times 3. It doesn't include the 164 eviction cost. And then during the time there was an issue with a pet at the unit, which would be a $75 a month charge. He contended that he didn't have the pet at the unit. The pet was seen a few times, but we're not worried about that charge at this time.
Pet, how much?
It'd be $75 a month.
Okay, and you said the reletting fee is usually at least a month's rent, or what did you say?
85% of 1 month's rent.
You need to give me some numbers.
$743 and 75 cents.
Okay, so you are saying that you're owed what at this time? June rent?
Correct. Do you want me to give you the number with or without the 875 he paid into the registry?
Yeah, give me the total amount that you say that he's owes.
In total rent?
For rent, yeah.
For rent, it is $2,075. I'm sorry, $2,175.
And so you're saying we want the rents. That's what you're looking for?
Correct.
Okay, so that's the total rent, and then there's an amount in the court registry.
Right, 1 month's rent is in the court registry.
Okay, so subtract that, we've got $1,300 in rent.
Correct. Correct.
Okay, so that's what you want paid. Anything else, sir?
That's all we're gonna go through with the court. As far as the collections, on the collections, it has the late fees, it has the court costs. But I mean, that's a matter he can do separately with the collections, or he can try to call us and work out an arrangement with us regarding that.
Okay, so you gave him till, are you saying that you did not give him till June to move out?
No, initially in May, we gave him the option to move out at the end of May and not go through the eviction process. And he declined to take that and instead stayed past the court date and past the eviction, then filed the appeal and wound up staying till June 30th, and then did move out June 30th.
When was the eviction? When's the court date on that?
That was on
May 25th.
May 25th.
Now, Mr. Williams, she kind of noticed how Mr. Geltman kind of didn't say anything while you were talking, and I was asking you a bunch of questions, right?
Yes, Your Honor.
Okay. Would you be able to go ahead and give him the same courtesy?
Yes, ma'am. I didn't mean to be so loud. It was in my head.
Okay. All right. So if you had moved out the end of May, we wouldn't have any issues. Is that what you're saying?
We wouldn't have gotten to this point, and he probably would have only, if he wound up paying the $875 into the registry, he would have only owed $425. from the April rent that wasn't paid. But we tried to work something out and we just couldn't come to an agreement.
Okay. One of his concerns, as you heard, is as far as what is the 1974? What does that include?
So the 1974 that doesn't include any money that was paid into the registry. So I'm not sure why it's 1974. My number has it as 2175. But for the paper's sake, if it says 1974, I'll just have to go by that. But the total rent owed was 2,175. The paper says 1,974. I just have to go ahead and go with that number at this time.
So if you subtract 875 from what's in the registry, you've got 1,099.
Correct. It may have been that the late fees were included in that. The lease does say that late fees can be priority posted and constituted as rent. Whatever payment is made will go towards whatever balance is owed before even the rent payment, according to the lease. So those may be late charges is the difference.
Okay, one of the main concerns for Mr. Williams is to be able to not have this reflected as an eviction on his record. Is there any way to possibly avoid that at this juncture, sir?
Is there any ability to make payment towards the balance owed?
Well, and we'll get to that. Obviously, that would be a prerequisite. So if can that happen as far as your mind is concerned if he meets certain requirements?
Yes.
Okay. And so Okay, so I still don't see anything that's matching up to the $3,639.61. But we're not going to spend too much time with that unless we need to. But Mr. Geltman, I'm
Yeah.
sorry, did you say something?
Yeah, if you would, there's also, the reason the number got to that high is when you turn it over to collections, we charge the collection percentage, which is 33% of the total, which is what the collection agency charges. So we had 1974 in rent plus the 743.75 reletting fee totaled $2,717.85. Then there was a 33% collection fee charged, which is $896.86. And the number came to, I'm not sure why you asked that number, but the number I have is $3,614.61. But like I said, if we're able to get some sort of payment or he's able to work something out, there's the ability for not that much to be charged.
Yes, sir. So this is what I've got, Mr. Goutman, if you're ready to go ahead and write down, and Mr. Williams, if you're ready to write this down.
Yes, Your Honor.
Okay. I have got a difference between paying $1,300 or paying $2,334.25. Now, how I got to that number is how I got that difference. Okay, so if you put down 1,300 on one side and then put $2,304.25 on the other side, this is how I came to the $2,334.25. Okay, I looked at took the late charge times 3. Is that what you're looking? Is that correct, Mr. Geltman?
Yes, correct.
That comes to $262.50. Reletting fee, $743.75. Court costs of $154. And actually, you're probably letting go of the pet fee, so we can subtract about $75 from that total. But then I add in the 174 minus what's paid in the registry, that comes down to $1,099. So if you actually subtract out the pet fee, we're looking at 225925. Or 1,300, which is the rents owed of $2,175. How I came to that is the rents owed and minus the amount paid in the registry of $875, it would equal $1,300. So, Mr. Gelt, would $1,300 satisfy and avoid an eviction record?
Yes, I mean, I just would need to know like a time frame. I don't know that a perpetuity would suffice, but I would need some finite dates and arrangement.
Not a problem. Definitely could go ahead and do that. So, Mr. Williams, do you understand the numbers I did?
Yes, Your Honor.
Okay, so let me go ahead and kind of put it to you this way. You were given notice of that the balance of $1,974 would avoid collections and avoid this getting on your record. So you understood that you were told to go ahead and pay that into a Dropbox, and whoever you spoke to tell you to do that. But that was your understanding. And as you can see from the math, you owed so much in April. Was that correct?
Yes, Your Honor. 400 and some dollars.
Okay. 425. And then May, you owed May rent.
Yes, Your Honor.
And then you stayed until end of June. You say you moved out the 30th of June and turned everything in, right?
Actually, Your Honor, I was moved out before I wasn't moved out. My belongings were there, but I was not staying there. I was paying for U-Haul and getting the things that I needed to move them. And I had spoke with an attorney. But I was never made aware of the agreement to leave at the end of May. I was under the understanding that I had till June 30th to have everything cleared out, as long as everything was cleared out.
Okay. Was anything provided in writing, Mr. Geltman, as far as you needed to move the end of May?
Ma'am, I'm sorry.
I know that there was some messaging through the online portal. I don't have anything printed.
Anything you'd like to share?
No, I mean, at this point, I would just, no, I'll just continue with the proceeding.
Okay. So if he had no notice to move, are you saying then he had no notice to move out by the end of May?
Well, he was given judgment for eviction was on May 25th, and the judge said he had 5 days to move or appeal. And so that's how that turned out. I do know that before we evict, we're a different kind of community. We try and let people move out before the eviction process happens if they can't pay. We really try not to go through the eviction process here. But sometimes, people just don't have anywhere else to go, or they just don't want to move. So then we have to go through the eviction process.
So you understand that even if your person was moved out, okay, you were staying there, the apartment complex couldn't really rent out the place. Would you agree, Mr. Williams? Because your stuff was still there, right?
Yes, Your Honor.
Okay, I mean, unless you wanted them to confiscate your stuff and sell it or throw it out, I mean.
Well, by the appeal, that was told that we would not be able to touch anything with the writ. I would.
Yes, of course, but you understand that your
Yes.
stuff was still there, so you were basically paying for storage.
Yes, ma'am.
Okay.
Yes, I am.
So with $1,300, which one do you want to pay? $1,300 or $2,259?
$1,800, Your Honor.
I'm sorry, say again.
I'm sorry, $1,300, Your Honor.
1,300?
Yes, ma'am.
Okay. What I'm going to do is I want to go ahead and reset this for a compliance review. And what I'm going to do is have you guys agree and come up with a written payment plan that is signed. And then at the end of that payment plan period, we will have a compliance review. Would that work, Mr. Geltman?
Are we able to get the funds that have currently been paid into the registry now, or do we have to wait
yes,
for the
sir.
very end? Okay, yeah, we can do that.
Okay. Well, yes, sir. So the thing is, basically, you will not to avoid the eviction record, to be able to go ahead and satisfy the payment, because that registry, that $1,300 says here's all the rent minus the $875 that's in the registry. You get that, Mr. Gutman?
It's gonna be a total of 2175 due to the registry. There's 875 in there right now. I'm wondering, do we have to wait till all 2175 is in the registry to collect?
No, you guys are gonna come up with a collection, a payment record, a payment agreement.
Right, is he required to pay that to the registry, or can he pay that directly to us?
That's something that you guys are gonna discuss.
Right, so that would be my thing would be, I would need that paid directly to us, and then I would need the 875 to be released. Those would be the conditions I would have to continue, to be able to not go through with the eviction.
Okay, do you understand that, Mr. Williams?
Yes, Your Honor.
I mean, is that crystal clear, really? He
Yes,
wants
sir.
you to go ahead and come up with a payment plan that's concrete, that you're gonna pay that.
Yes, Your Honor.
Also, I'm going to release the 875 that's already paid in the registry. That's what brings it down to $1,300. You understand?
Yes.
Okay. And there will be no, and if you stick to the plan and get him paid off, the apartment paid off, there will be no eviction on your record.
Yes, Your Honor.
And we will also, drop the collection, the balance that's currently in collections, but I can't drop the balance that's currently in collections until it's paid.
Yes.
Yes.
So basically, he's got to have a couple things hanging over your head.
Yes.
Right? Okay, so we're gonna have, hey, you're gonna get this done, and then you're going to also have this hanging over your head. This $3,000 hanging over your head. You can either pay that, or you can pay 1,300, or you can pay 2,000.
Yes, sure.
And you choose to pay 1,300.
Yes, Your Honor. I understand.
Now, understand that Mr. Geltman may not, I'm going to let you guys discuss it, but Mr. Geltman, I'd like for you to take a few things into consideration as you guys discuss a reasonable amount of time to make this payment, take a look at. And so as to give him something, and then we'll come back and see if we need to do anything after that, okay?
Okay.
All right, so you guys get into a breakout. You guys call each other and then call the court when you finish up with your conversation, and then submit an agreed order with the payment plan to the court, okay?
If I may, just real quick, if he'll just come up with something and email it to us, and then we'll call him to let him know if that's acceptable or if we need to change it. But go ahead and write down what you think you can do, what kind of payment arrangement you can make on the 1,300, email it to us, and then we will give you a call to let you know if that's acceptable.
Do you understand that, Mr. Williams?
Yes.
He's saying, hey, you make the offer to say, this is how much I can pay, when I can pay.
I cannot do it. I'm sorry. I'm so sorry again.
Can you do what, sir?
I was about to make an offer. If I was trying to see if I can make an offer.
Sir, it's 6 o'clock. My court
Yes,
reporter
I
needs
understand.
to go. I need for you guys, that's why I'm telling you, you guys get together and talk about it. I don't need to sit here and arbitrate your negotiations. And he's already told you how he wants you to communicate with him.
Yes, sure.
Email him something with your proposal. He will go ahead and look at it and see if he agrees with it. Then he's going to give me an agreed order that says, hey, this is what we want. This is what we have agreed on. And this is what's going to happen and when it's going to happen by, okay? And then
Yes,
we'll
ma'am.
come back and visit that. I'll sign that, and then you guys can set it for a compliance hearing, if need be, okay?
Okay,
And
and
if
just
not, compliance.
that the 875 will be released, and I'm able to pick that up, or that gets sent in a check?
That is something that's going to be all in your order, sir. you're gonna have an order, you're gonna send me an order for me to sign that states, outlines the agreement, what we talked about today, what you want, and set a date for a compliance hearing. Okay?
So with that in mind, I wouldn't be able to get the 875 until the compliance hearing.
No, sir. No, sir. I need an order. I need to sign an order.
Right, I went to the court and they should have put one in the file for you for this. Do you not have it for the release of the 875?
I probably don't, but it's gonna be part of the order of what we agreed to today. You can maybe attach it as an exhibit if you have that already, and I can go ahead and sign that, and so you don't have to do it. But I need an order that says, hey, this is what we agreed to today, and this is how it's gonna happen, when it's gonna happen, all of that, and then this is what I want right now.
Okay.
Okay?
All right, thank you.
You're clear, Mr. Geltman,
Okay. Thank
what
you.
you need to do.
Right, yes.
Mr. Williams, you're clear on what you need to do?
Yes, Your Honor.
We're done. Thank you very much. Appreciate it. You guys are excused, and it's order to come. Right?
Thank
I will mark this as order to come.
Thank you.
We're
Thank
good.
you, Your Honor.
All right. Thank you.
All right, Judge, I'm gonna try to pack it up before it rains.
I've been hearing thundering and lightning.
Oh, yeah, it's been dark, but it hasn't, maybe it's just gonna pass the clouds or something. Probably something light.
Yeah, you better run.
I'm hopeful. Okay, I'll
Sorry to
see.
keep you so late.
Oh, that's okay.
You know, these pro says that 10 minutes, they just left. Okay.
Yeah,
Go
that's
ahead
okay.
and the recording.
Oh, yes, ma'am.